Let's turn now to a discussion of the fiduciary duties of directors in a corporation. Like when we were discussing the principal-agency relationship, directors are deemed by the law to stand in a fiduciary relationship with their shareholders and to owe them certain fiduciary duties, including, most importantly, the duty of care and the duty of loyalty. And so, because of these fiduciary obligations, it is possible to find litigation where shareholders are complaining about a particular transaction or step or decision that a group of directors have made. And the way they are complaining is they're saying that whatever it is the directors have decided to do somehow violate the duty of loyalty or the duty of care that they owe the shareholders. And the shareholders are thereby looking to ask a judge to either enjoin the transaction or, more likely, in hindsight, to now impose damages in order to compensate the shareholders for that breach of duty. The content of the duties, while similar to what we studied in the agency context and the partnership context, are different. And the way the analysis is done to determine whether or not a court will intervene in the corporate decision-making that is being complained of is also different. And it's a little bit more complicated. And so I think it is useful to get an overview of how fiduciary duties work in the corporate director context, to have an analytical framework, a kind of flowchart, if you will, on how courts go through this fiduciary duty analysis. So let's see if we can draw a picture that helps you see how courts apply the fiduciary duty analysis in the corporate context. As you'll see, it's not quite the same as what we saw in the agency or partnership setting. It's a little bit more convoluted. And so hopefully this schematic will help you parse through the various cases you're going to read about duty of care and duty of loyalty. I think the very first thing you should ask yourself anytime you see a shareholder complaining about directors and the decision that the directors have made is whether or not you have a duty of loyalty question, right? Because that separates the cases into two broad categories. Duty of loyalty cases are special in that they have to run through a whole separate analysis than duty of care cases. And duty of loyalty cases usually also involve a duty of care analysis where the reverse is not true. Okay. So what's a duty of loyalty problem? Well, look for a situation where there's a conflict of interest of some kind, where one or more of the directors who have approved a particular transaction sit on the other side of the table, where they have some interest in the deal that's being discussed, right? And so one of the cases you often read is about the CEO has an opera singer wife, and the Celanese Corporation is approving a very lavish program that includes the employment of the opera singer. Now, does that special interest that the CEO had in the issue create a duty of loyalty problem? And the answer is, well, yeah, unless certain things are done, there is a potential violation of the duty of loyalty. The other cases you'll see is situations where a director has a business opportunity that he or she wants to pursue independent from the corporation. So a case we often read is one that deals with a cell phone company where the director is the owner of another cell phone company and wants to pursue a new license. And the question is, can he pursue that license on his own, in his own company, when the company he owes duties to, the first cell phone company, might want to pursue the same license opportunity, right? Those kinds of questions are the ones that are duty of loyalty problems. So look for that conflict of interest, right? And to make it, let's go down the straight way first and start with when you have a duty of loyalty problem. And the answer is yes, I do have one. What do I have to ask myself next, right? And so we put a yes here. We'll draw an arrow. Because when you say yes, we have to go to box 2. And we'll call box 2 the effective approval box. All right, and I'll explain in a second what I mean by effective approval. Well, the first question to ask yourself, if you have a duty of loyalty problem, you've said yes, there is one, not no. Did you see approval from the shareholders? Okay. And what courts have decided is that in order to sanitize, if you will, a duty of loyalty problem, in order to overcome the fact that a approval of a transaction in which you're on the other side of the table as a director is voidable, right, because it's a violation of your duty of loyalty, one thing you can do is you can get approval from the shareholders, right? Now, who are the shareholders? Well, the courts have read into that it has to be the approval of a majority of the disinterested shareholders, the shareholders who themselves are not possessing a conflict, right? And that is to deal with those situations where, let's say you have a controlling shareholder who also happens to be the director, right? Can that controlling shareholder sanitize the duty of loyalty problem by simply voting in favor of the deal both as a director and as a shareholder? And the courts have quite rationally said no, right? That in fact what you need is the approval of a majority of those shareholders who don't have the conflict, right? Because otherwise it'd be a meaningless pro forma exercise to get the shareholder vote, okay? And the other thing you need in order for approval to be effective is that it has to be given after adequate disclosure, right? Informed consent, I guess, is the way of thinking about it. Were you given by the board or the company before you made your decision as a shareholder to ratify the transaction that suffers from this conflict of interest problem all the material information that you would reasonably expect to have or need in order to make an informed decision? That's the question. And if you were not given that information, so in other words, if you weren't told about the conflict itself, the fact that there was a conflict, and you weren't told about the economics or the underlying rationale for the decision before you gave your consent, well, your consent isn't helpful in overcoming the duty of loyalty problem, okay? So to be effective, it has to be informed approval. Right? But let's assume for the moment that the answer to our question is no, right? That in fact you don't go out and get effective approval from your shareholders. Well, then the next question you have to ask yourself is, did you get effective approval, and I spell this wrong all the time, disinterested directors, right? So the next question then is, well, if I didn't get shareholder approval, did I get the approval of my brethren or my sisters on the board? And did they sanitize the decision that was made where I have a conflict? And in order for that to be true, I would need a majority of the disinterested directors to, after being informed about the situation and the fact of my conflict, they would then nevertheless approve the transaction despite the conflict, okay? So again, same idea, it has to be informed approval, and two, it has to be the approval of those people who themselves don't have a conflict. Do they have to constitute a quorum? No. Do they have to constitute a majority? No. Can I set up a committee to deal with this, a committee of disinterested directors, independent directors, and have that committee be a small part of the board and still get the sanitizing effect? The answer is yes. Do I have to worry about whether or not the people on that committee or the people I'm counting as disinterested directors owe some kind of obligation to the interested directors or under some kind of influence? Are they dominated, if you will, by those other directors? Yes. If there's strong economic ties between the so-called disinterested directors and the ones with the conflict, well, that might not be good enough, right? And there are cases where because the directors who are approving the transaction owe their position to the other controlling shareholder or have substantial economic ties or interest with the other shareholder, that the court says, that's not good enough. They really weren't disinterested, okay? But if they are disinterested, if they're independent, if they're not under the sway of the other shareholder, and you get all of the majority of them to agree with the transaction, it will help in overcoming the duty of loyalty problem. But let's again assume, because we're going to keep going down our analysis here on this side of the picture, the answer you get to that question is no, you did not get either shareholder approval or disinterested director approval. So where does that take you next? Well, this is where you get to the spot the courts hate to get to, and you'll see a lot of these rules are designed to avoid ever getting to this spot where the court itself, and then I'll spell it correctly, I hope, intrinsically fair. The court itself has to make now a determination whether the transaction that is being complained of, right, despite being approved by the board, because we don't trust that approval because of the conflict problem, we're going to ask the judge, the court itself, to substitute its own independent business judgment to determine whether it believes that the transaction is fair to the shareholders and to the corporation, right? And the answer, if the answer to that question is yes, even though there was a conflict, I still think it was a good deal, well, then there's no damage, and so no liability, right? But if the answer is no, right, the court does decide that the transaction can't meet that test, and the burden of proof is now on the directors, not on the shareholder who's complaining. So if the directors can't carry that burden, can't establish to the satisfaction of the court that the deal they approved was intrinsically fair, well, boom, now you have breach. And a remedy will ensue. Okay? So that's the basic analysis of one half of the kinds of one side of the cases when there's a duty of loyalty problem. Okay? But let's consider another line of thought. Right? Let's say the answer to our first question here in box 1 is actually new. Okay? So we don't have a duty of loyalty problem. Where does that then take us? Right? Well, now we leave that chain of analysis, the duty of loyalty chain, and we switch over to this other side of our picture. We'll call that box 4. And we have to ask ourselves, well, did the board that made the decision to approve the transaction we're talking about do so with informed business judgment? Okay. And what does that mean? Well, that's the concept that we learn about and we get a sense for what it means by reading probably the most famous Delaware law case, one of the most famous corporate law cases there are, Smith versus Van Gorkum. And I like to characterize Smith versus Van Gorkum, the moral of Smith versus Van Gorkum, as telling you that you have to, quote, do the dance. That's my less than respectful way of describing the judgment and the decision in that case. And what I mean by that is what the court is telling us is that if you go through the process of making a deliberative decision, okay, you do what most people would expect one to do from if you're trying to reach a informed conclusion, informed decision as a business person. You collect information, and what does that mean? Well, you listen to your experts, you listen to your management team, you get reports from them, you collect the kind of raw, basic information that anyone you would expect to collect in order to reach a conclusion about a merger, a business transaction, what have you, right? Do you go kick the tires yourself? Do you spend time out in the field doing empirical research? Do you go get a massive education in finance or accounting? The answer to all those questions is no. But do you make sure that you ask questions of the people around you who are have the best access to basic information, and you get from them the kinds of answers that a reasonable person would want to have before they make a choice? Yes. Okay? Do you spend time debating it? Do you spend time kicking around alternative ideas? Are you having an open-minded discussion? And the answer is you should, right? How much time do you spend on it? Well, I think that will depend on the context. The more time and the more anxiety you evidence in before reaching your decision, the better. But can it happen in a few hours? Certainly, right? People realize that very significant, large business decisions can and often need to be made very quickly, right? But if you can come back a next day or put it off for a week and try again and have more meetings, well, that's better, right? But as long as you go through a process that has deliberation in it, that has fact gathering in it, that has question asking in it, you're going to benefit from something called, so if it's informed business judgment, the business judgment rule. And the business judgment rule is a judge-made concept that says that we will presume that a board has exercised due care, has fulfilled its duty of care, provided that there's no duty of loyalty problem, because that overcomes the presumption, that makes the presumption unavailable, and provided that we're not in box 5, right, which would be our next analysis, and that has to do with bad faith and waste, very rare situations and very special situations. If we're not in bad faith or waste situation, rare, and we're not in a duty of loyalty case, and so long as our board has, quote, done the dance, as I put it, has gone through a deliberative process, we're going to say that they benefit from the business judgment rule, that presumption that they did in fact fulfill the duty of care. And so if we are benefiting from that presumption, and we ask ourselves if there's bad faith or waste, and we come up with the answer no, we'll talk about what that means in a second, well then there's no liability. All right, well, let's go back. What does it mean to have failed on the standard of bad faith? Well, that requires subjective bad intent, right? If you can show that in their mind they were doing it, the board was doing it, approving a transaction not to in the best interest of shareholders, but for some evil purpose, well then sure, you're going to have an ability to recover. Okay, how likely is that ever going to happen? And also, courts have saved for themselves the extreme case where if you can show that a decision was made that no reasonable person could have accepted as serving a legitimate business purpose. It's just so outside the realm of making sense, right? That despite having gone through the dance, right, we're still not going to countenance it, and we're talking about some very extreme kinds of situations where it's just smells on its face, right? Okay, if that's true, yes, maybe you have a remedy, right? But if it's not true, if neither of these things are true, and we are exercising or living in a business judgment rule situation because there was adequate process, there's not going to be any liability. So there are a couple of spots here where we did not completely fill in our box, all right? So let's return for a second. We dealt here with the situation under effective approval where we did not get shareholder approval. So let's ask, well, let's say we did, right? So we had a duty of loyalty problem, right? There was some kind of conflict of interest on the board that approved the transaction. We went and disclosed that conflict of interest and some of the material facts regarding the transaction to our shareholders, and we got a majority of the disinterested shareholders to say, well, nevertheless, we're approving the transaction. Does that mean we are done, right? And the answer is not quite yet. You still have to come over here, right? And ask whether or not, despite the shareholder approval, was the board decision that's being reviewed marred by bad faith, so actual subjective ill intent, or did it constitute waste, right? Shareholders are not given the right, in this context at least, to approve something so outrageous that it's unconscionable, incountenanceable. Well, you know what I mean. Where a court just can't deal with it, all right? So beyond the pale. All right? So that's one step we didn't finish off. We closed that off. So the next one is, okay, instead of that, let's say we had a conflict of interest, and instead of going to the shareholders, we went to the disinterested directors, and they, in fact, approved the transaction. Are we done? And the answer is no, we're not quite yet done. We have to still go through this analysis, right? Because what we have here is, while the duty of loyalty problem has been overcome, right? We've now taken ourselves outside of the void per se context, right? Because we've gotten the sanitizing vote of the disinterested directors. But now we have to ask ourselves the next question, and that is, was the decision by that group itself a violation of not the duty of loyalty, because we've solved that by their approval, but now the duty of care? Okay, so that's this chain of this side of the chain of analysis, right? And well, the question, once we're in the duty of care world as opposed to the duty of loyalty world, right? And maybe it's useful to label these sides. Okay, once we're in the duty of care world, the question is, okay, did that decision reveal informed business judgment? Okay, so even if we get the approval of the directors, in theory, they could have approved it in such a haphazard, thoughtless way that that approval itself is invalid, and therefore there's still possibility for breach, right? But so you still have to finish the analysis by going over to this side of the analysis to see whether the directors themselves, the disinterested directors themselves, did a good job in evaluating the particular conflict problem. Okay, and then the one last spot that we haven't finished is this one. Let's assume we are in the Van Gorkum context, and this will be not very common. There are not a lot of cases where the process was so deficient that a court will not give the judgment the benefit of the business judgment rule, but it does, in fact, in theory, exist, and as we saw in Van Gorkum, was a problem. And so then, what happens then? Are we done? And the answer is no. We're back to where the court never wants us to be, putting them in the position of having to now substitute their own judgment for that of the board of directors in determining whether or not the transaction that's being complained of is itself fair, right? And again, the burden has shifted, and now it's the burden of the directors to prove to the court that, in fact, the deal that got done, despite them having rubber stamped it without due deliberation, is nevertheless still fair, therefore no damage, therefore no liability. But if, in fact, they can't carry that burden, well, that's where we'll find a breach and have some remedy being given by the court. Okay? Well, I hope that schematic, that picture, helps you put in place all of the cases you're going to read about the duty of loyalty and the duty of care. It is very important to sort of fill in your qualitative understanding of concepts like what is a self-dealing transaction, like what is a disinterested director, what do courts think about when talking about intrinsically fair, and most importantly, and probably the most practically useful information that you should glean from the cases is, well, what does it take to be deemed to have exercised informed business judgment? Or put differently, how much do you have to do to have, quote, done the dance, as I put it? How much do you have to do to have shown a process that's going to earn your client, the board, the benefits of the business judgment rule. Because in day-to-day corporate life, that is probably one of the most important standards that your client is going to seek to fulfill, right? Because obviously, bad faith and waste are the kinds of things you don't often worry about in day-to-day business. But being in this position, where you're putting yourself into the hindsight, Monday morning quarterbacking of a court about the fairness of a transaction you've done, is certainly not where you want to be. And since the cost, if you will, or the burden of getting to be in this position where you get the benefit of the business judgment rule is so low, right? It is just going through the steps, right, with some care. Why not do it? And so lawyers spend a great deal of time focusing on making sure that the process that a board goes through in reaching decisions is one that's going to earn them the protection of the business judgment rule. Okay? And so spend your time reading the cases, trying to glean from them what that process consists of, how it should look, what's going to be important, what are the factors that you can use to make sure you're giving your client a roadmap for earning this protection, because it's worth it.